Hello, good afternoon, and welcome to The Law. It is your legal light. It is your health law. I'm Samson Lardy Anyenini, and last week during our discussion, there was someone who expressed great surprise when the education was given that the person could simply look for the nearest court and ask the registrar of the court to assist them do their case, and it will be done for them. People have been shocked. So you didn't know that you could actually do your own case in the court. But the law, facts, and truth, which decide your case when you go to court. We're right back to get into this education. Welcome back. Daniel Cram is lawyer and author. He is with Adom Legal Consult. You are familiar with him. He's been here and assisted you to appreciate more particularly how the criminal justice system works. Musa Ahmed is head Ahmed Legal Consult. He's also no stranger to the law. Gentlemen, good afternoon. Thank you very much for making time to join us this afternoon to educate our people.
Good afternoon, Samson.
Good afternoon.
Great. So to start with, I'll start with Senior Ahmed.
Yes.
Somebody expressed the shock. It was sort of a shock of his life to hear that he needed to do letters of administration and he didn't have money. He said they couldn't hire lawyers, and he was giving the education that he could simply walk to the nearest district court and ask of the registrar, and he'll be assisted and things will be done for him. He could do it without a lawyer. Can you help many more people? And this afternoon, I've asked somebody else I expected to know who said he didn't know.
Anyway, justice in the first place emanates from the people of Ghana. And it shall be applied by the judiciary in the name of the Republic. So in the first place, justice is coming from the people, in whose name justice shall be delivered. So therefore, the prime actors in the judicial system in terms of delivery of justice is the same people. So the Constitution and the laws of Ghana allows a person to decide by election whether he will pursue his case in court himself personally, or he will do so through a lawyer of his choice. That is why when a person commits an offense, he is arrested. The Constitution obliges the arresting officer to explain to the person the reasons for his arrest, and then his right to a lawyer of his choice. And these are options available to him, but it is mandatory for the officer to inform him that you have a right to a lawyer of your choice. So he will choose to go by a lawyer. So if you apply this to a civil case, which is mostly dominant, the example you have given, the law says that you can go to court and issue a writ, or apply for letters of administration, or apply for probate, either by yourself or by a lawyer. So the options available to you are two. You just decide the one that is convenient for you.
But this is a very technical area, law. Will it not be suicidal to choose that I will do my case myself, do my defense myself, or something of the sort, when potentially you'll be facing a lawyer on the other side?
Indeed, that is the case. but it's a matter of choice. When it comes to advice, you may advise the person that it is better for you, given the complexities of the law. The law has procedures that you ought to follow, and those procedures are within the purview of a professional who is a lawyer, or the registrar of the court, or a judge, or somebody who has legal knowledge, and you need to get somebody to guide you. If the person decides to go by himself, I'm sure the law also will make room for him to be able to operate within the atmosphere of the court system, which will be flexible for him. But if you ask me for my advice, I would say that if it involves your rights, it involves your right. Let's say somebody, you have a contract with somebody, there is a breach of contract, or somebody is trespassing on your land, somebody is seizing your property by force, say the government wants to take over your land. These are complex cases. In such cases, you must always go for a lawyer. But if there are issues like you want to take probate, you want to go for letters of administration, I don't think they are complex. The registrars of the court could assist you, draft the documents, put everything together, and file it. Your appearance in court is the most important thing. The judge would have a duty, because justice emanates from the people, and it shall be administered in the name of the republic, which is the people. It means that the judge must guide him if he has no lawyer. The judge can even appoint a lawyer to do the case for him in court. And that power is also vested in the judge.
Right.
So that we call it legal aid. You can, and so that is the position of the law.
Right. So what you just said reminds me of a situation. Very recently, I was in the Supreme Court to do my own business, and a gentleman had brought an application for extension of time to be able to, for leave, for him to be able to file his appeal. And he had done the process by himself. And the court granted him his desire, but then, just unilaterally appointed me to assist him to bring what he had to do. It must take people who are bold, and have some better level of education around the law to be able to do such a thing, that the person will walk all the way to the Supreme Court by themselves. When you go to the district court, the circuit court, you see criminal defenders, you see accused person. Some of them are defending themselves, and the judges are very cooperative. They are helping them. Please unmute your mic. Your mic is muted.
So that is the beauty of the law. You see, because we operate a democratic system of government, and the rules are made to favor the citizens, the law itself must be obeyed by everybody. But when it comes to seeking justice and rights, it is an option available to every person to decide how to go about it. But as I said earlier, if your case involves a complex case or issues, it will be in your interest to go for a lawyer. You may practically take the example of someone who has a headache, just a common headache. You may go to the pharmacy and buy yourself a painkiller, but that is only to cure you of a common headache. If you happen to have a complex medical condition, I'm afraid going to the pharmacy to buy yourself a medication will not help you. So you can apply this scenario to a case of a litigant wanting to go to court. If your case is complex, just as someone who is sick and his sickness is complex, he must consult a lawyer, a doctor. And that is the difference, and that is a point you must always have at the back of your mind.
Right. Yes. So, Daniel, some 60 years ago, the court held in George versus Wainwright that there was a requirement for state courts to appoint attorneys, that is lawyers, for defendants who could not afford to retain lawyers, as in counsel, on their own. And it's also reasoned that there is a fundamental and essential right, that was a fundamental and an essential right, unless completely and intelligently waived. Situate this in what, Senior Ahmed had just began to explain.
Thank you very much, Samson. When it comes to the right of counsel, the right to a lawyer, it is so fundamental that I would say that all other human rights depend on that. If we say you have the right to freedom of the press, right to liberty, right to property, yes, all these rights can only materialize when you have an effective legal representation in court. And so in established democracies, the judiciaries and the courts we have are so keen and very much alive to this very human right that when a person is going to court, we know the basic functions of the court are to determine the rights and liabilities of parties that appear before the
Daniel's connection is breaking. Hello, Daniel. Okay.
Learned to be able to do an easy task. And so judges are always, minded to assist those who do not have the means financially.
All right. Daniel's internet is getting a little bad. We'll hope that it gets sorted so that he gets back to us. In fact, Daniel has written this article around this subject matter. Hello, Daniel. Okay. I understand it was stable, but just frozen again. He's written this article about this situation and has a very good introduction to the questioning. Yes, Daniel. Hello, Daniel.
Hi, Samson.
Right. So you were making a point. Please proceed. Okay,
yes, Samson.
Yes.
Yes, what I'm saying is that anyone who has a case in court has the right to say that even though I have the resources,
All right. Okay, so we have to find another means by which we can reconnect Daniel. But there's a point he's beginning to make that it's not only when you can't afford, but there can be a situation where you can afford, but you feel confident enough that what it is that you're going to deal with in court, you can do it by yourself. In that case, you may be able to proceed on your own. There are times when people start and then in the course, they say, okay, I think at this point I need a lawyer to come in, and bringing a lawyer in midway, or even judges may advise that from the way things are going, you may need to get a lawyer. And bringing a lawyer midway may also mean perhaps maybe something has been done, not done right. They need to go back and retreat all over again. But this is not to discourage that the law allows. And as Senior Lawyer Ahmed said, there are cases where they are simple, they are easy, they are not complex. That's the word he used. They are not complex, where you can just approach the court and the court officials, particularly the registrar. They have an obligation to assist you to be able to put your case before the judge. And the judges are also almost always proactively encouraging and assisting people who don't have lawyers to help them go through the process. There are places where you don't really have lawyers around. You may have one or two lawyers, and everybody is sourcing one or two lawyers. It may be difficult to, even get a lawyer. So that's understood. We have Daniel back. All right, so we'll try and get Daniel back. I'll get back to Lawyer Ahmed. Having heard, for example, the perspective from which Daniel was coming from, is there something, that you would like to say additionally? Any caveats that you want to put in some more? Any encouragement, particularly for people in the hinterland who still need legal services or need to go to the court?
Yeah, the truth of the matter is that every person needs a lawyer of his choice, especially when you look at Chapter 5 of our Constitution. The fundamental human rights of the individual are enshrined in Chapter 5 of the Constitution. And they range from personal liberties, liberty to own properties, free speech, attend religion of your choice. There are so many basic freedoms. And when the law makes provision for freedoms and rights, the same law may be used to violate your rights. So what happens is, when your rights are violated by one other citizen, the police, the soldiers, any other person within the state or outside the state, you need to vindicate your right. You need to assert your right. And by so doing, you need to invoke the jurisdiction of a court of competent jurisdiction. Now, the fundamental human rights, for instance, to enforce it, you have to go under Article 33 of the Constitution, which says that you have to file your petition or case before a justice of the High Court. And the provisions are all there. As such, it's a complex provision. So you need to get a lawyer. You may not be able to do it on your own. The rules of court that you have to follow, the procedure in preparing your writ, you have to plead matters of fact only and not evidence. These are professional in nature. You cannot easily go about it unless you have a guidance from a professional lawyer. So to that extent, you need a lawyer. And it is fundamentally correct when my colleague said that because of the nature of our system, the freedoms that we have to enjoy, those freedoms will become only meaningful when you have a lawyer by your side. And that is true. You will even find that recently the whole former president of the United States was indicted. Yeah. He's been a president before. He signed laws, he's enforced the laws, but when he was indicted, he went for a lawyer. And he also decided to sue his former lawyer for certain breaches of legal professional privilege. He went for a lawyer. He didn't go by himself. So these examples alone should tell anybody that you need a lawyer. And even though you can file your case by yourself, you still need a lawyer to give you guidance, to enable you enjoy your freedom, your rights as enshrined in the Constitution.
Right.
So that is,
Thank you. Yes, Daniel, we have you back. So continue with your point.
Thank you very much. I was making a point that almost all other human rights or fundamental human rights depend on, effective legal representation. When you don't have a lawyer, all other rights seem to be meaningless because you cannot effectively, or you may not be effectively defend those rights. And so I said earlier that when you have a litigant who has all the resources and who knows that he has the right to a lawyer of his choice, decide. So the person decides that I want to go and defend, waive his right to counsel. And the system allows it. The system does not impose a lawyer on anybody. It is only when the court finds that the person is incapable of engaging the services of a lawyer that the court may advise or may sometimes appoint a lawyer to assist the person. But litigants should understand that they can intelligently waive the right to counsel. That should be done sparingly. You don't have to rush to waive your right to a lawyer, because as Ahmed said, the courtroom is a place where rules are applied, where laws are applied. And so if you are not well versed in the law, you don't have to take chances to say that maybe you are an English speaker or you have some education in some other fields. That is not law. And so you can do your case. You don't go to court only to speak English or to exhibit linguistic skills. The law has rules, has principles that one must master before one can defend oneself in court. And that is why it is important that everyone going to court must consider engaging a lawyer. I have always said that engaging a lawyer today is not, luxury, but necessity. So you don't say that you can just waive it and have your rights defended. No, you have to get a lawyer. Otherwise, you may not be able to defend yourself in court.
The law's provision that you can represent yourself, what is the use of that from the point where you are now coming from?
Yes, the law allows a person to go to court without a lawyer. When you read our rules of court, the criminal procedure rules, the civil procedure rules, they are always couched in such a way that the law allows the party or the party's lawyer. That is how the rules are always couched, either the party or the party's lawyer. And that is fundamental because the lawmakers, seek always to give people the opportunity to consider between either going to court by themselves or engaging counsel. I said earlier that the law doesn't force anybody to exercise any particular right. And here, the law will not force anybody to engage a lawyer. Let us not forget that lawyers are not gifts, or legal services are not gifts that people can just take home. No, you engage a lawyer at a fee. And so much as the law says that you have the right to a lawyer, you go there, the lawyer will charge you within the appropriate scale of fees.
So,
and it is not everybody who can pay.
The state has made provision for legal aid. So people who can't afford may go to legal aid and they will get help. But there are situations where you will not even get, legal aid is not even available by way of the lack of the numbers and everything else. Musa Ahmed had said earlier, the class of things that you could decide to approach the court, say, through the registrar of the court to assist you to do without worrying too much. In your case, what will constitute some of that list?
My view is that the registrars of the courts are there to assist litigants who are not represented by lawyers. But we admit that the registrar only helps you to prepare your documents. And once the case is placed before the court, after the documents are filed, the registrar doesn't go to the court to represent you. We know that in legal representation, a fundamental beginning is where the lawyer prepares your documents and files them before the court. And another essential stage is where the lawyer goes to court to orally argue out your case. That is where advocacy comes in. So if you get a registrar to prepare your document and he files them, and you are in the court yourself, let's ask, how do you apply the law, the rules to your case?
So my
to
question,
make out your case?
my question is, what will be in your list of matters that, you know, in the circumstances where one cannot afford counsel or does not have legal aid, can proceed to do them? Because there are some, as you said, once you get the help to prepare the document, it's almost as if it's done. Some judges may not even require you to make an argument. They will look at the paper that has been filed and then give you what must be given if you are deserving.
Yes, I heard Cindy Ahmed mentioning estate matters where you go for probate or letters of administration. But usually we know that simple cases that seem to be simple turn out to be very complex in court. And so I would say that when you have any matter, especially criminal matters, don't underrate or underestimate anything. Don't say there's a small case.
Okay, we have another, connection issue with Daniel Krang. We'll continue from here to the question that has been posed on as we had advertised. Now, Musa Ahmed, what will you say when I go to the court? When people appear before the court, sometimes there is an outcome. People are surprised. They are going to the court. They are so confident that things will, go in their favor, and then things don't go in their favor. We are told that there are some people too, when they win, they are surprised because they didn't expect to win, and so on. What is it that decides one's case when they put them before the court?
Is this question directed at me?
Yes, please.
Okay, I was off. So, yeah. What is it that decides a person's case? Well, the rules of court provides, apart from the judge's perception, the theories which affect the judge, there are various theories, but those are for the academicians.
That's right.
But for practical purposes, when you are talking to the ordinary Ghanaian, you have to explain the nature of decision-making process. Now, first, you have to bring a case that you can fall within what we call a course of action. If your case is not a case that is receptive to the law, then you will not succeed. You must also have capacity. Capacity in the sense that you must be within the law. Your rights must have been infringed directly for you to be able to have that capacity. The law has that notion of capacity for you to fall within it, to be able to classify your case and pass the test. These are preliminary matters. But when it comes to the actual decision making, several factors go into it. The facts of the case. If you file a case, you must have basis for filing the case. You must have legal facts. You have to be able to tell your story to the judge. And the law has parameters within which your facts must fall within. If you don't situate your fact situation clearly within the parameters, your case will fail. Now, when the facts are presented to the court, the rule is that you don't mix your facts with evidence. And it is always good to give an example. If you go to court and tell the court that someone has slapped you, and you make a charge, or you sue the person for trespass to your person. Now, the fact situation is that the person has physically assaulted you on a certain date, at a certain time, at a certain place, geographical location. These are the facts. But the witnesses or the evidence, the medical condition that appeared after the slap, which is the document that you obtained from the police and you presented to the doctors and they examined you and wrote a report, this will constitute your evidence. Now, you don't come and parade that piece of evidence within the facts. If you do that, you are going against the rules of pleading. And when you go against the rules of pleading, your case will fail. So, therefore, you must always get a lawyer to be able, as again, that is what is taking us back to the need to get a lawyer. You must get a lawyer to plead material facts and place it before the court. And then a certain procedure will be followed again. You have to file your witness statement after what we call close of pleadings. The defendant, in his case, will have to file a defense or counterclaim, or file only defense. After filing the defense, which are also matters of fact, the defense will constitute matters of fact. After the defense, the defendant has filed his defense, the plaintiff again will have to come in and file what we call a reply, which is a response to the defense. All those are matters of fact. Of course, there are situations where you can plead the law, but those are limited to certain exceptions. For instance, when you are pleading, you are saying that there is limitation. It is law. You have to plead it in the statement of claim or in your defense or in your reply. So these are the exceptions.
Limitation,
so relevant
to say
facts,
the person is coming to court late.
The person is coming to court late.
When you say there are limitations, I want you to break it down for our viewers.
Yes. The limitation comes in, it depends on what you subject matter you are looking at. For instance, in Ghana, there is a rule that if you sit by and allow somebody to usurp your right over a piece of land for a period of 12 years, the law will not allow you to come back and assert your rights unless you meet certain conditions. So this is an example of limitation.
All right.
We have torts, we have contracts. One may be 3 years, one may be 6 years, and you will not be allowed because the principle is that litigation must always come to an end. That is why the law sets limits.
All right, so let's proceed. You were getting to how, what will be used to make the decision about your case.
That's right. So at the end of your pleadings, your statement of claim, your defense, your reply, then the lawyers or the parties will file the issues which will go to determine the case before the courts. And we call it, in the legal principle, we call it application for directions. You file the questions. You put out the questions upon which the facts will be and the evidence will be determined. Now, when you have filed this and you are the appointed date, you appear in court with your witnesses. You give your evidence. You present your evidence to support your case. Now, because of the rules of natural justice, your accuser will also be given the opportunity to respond, and you'll be cross-examined. These are all procedures. Now, at the end of it, the decision has to be taken by the judge. And that is where I said so many theories have been propounded. We have the reformist theory, we have the Blackstone theory, we have the realist theories. They are all talking about different things, and they say they go to affect the decision-making process of the judge. But as I said, those are for the academicians. But when you come in practical terms, the judge will have to consider the facts, the evidence. He has to evaluate the evidence. he has to apply the relevant law, whether the parties know the law or not. Then it is the duty of the judge to apply the law to the facts of the case and come to a conclusion. The law mandates the judge to come to a conclusion with reasons. You must give reasons for your decision. If you don't give reasons for your decision, when the case goes on appeal, it will be set aside. Now, there has to be a conclusion. You have to pronounce on the reliefs that the party is seeking. Let's say the party is asking for recovery of a vehicle that was unlawfully taken from his premises. And that is the relief he's seeking. At the end of the case, when he has presented his facts, he has brought the evidence, he has been cross-examined, he's finished with the trial, it is the duty of the judge to make the decision and finally make the orders to either grant the relief or the case that the person or the claim that the person is making, or to refuse it.
So
the last part of it will be cost.
Right. So
the cost follows the events.
From your presentation, in sum, is it the law, is it the fact, is it the truth that is determined in court?
I must say that, you see, when you go to court, you are given either the Bible, the Quran, or you affirm. Now, when you do, you state before the judge. That is the commencement of the case. After filing all those processes, the first commencement of evidence is for you to take an oath. And within the oath, you say, I do state that I shall speak the truth, the whole truth, and nothing but the truth. So it means that the law recognizes truth as part of the decision-making process, apart from the facts.
But normally, let's say there are two parties. The contesting parties, everybody say they are telling the truth, yet they have divergent, views. How does the judge get to know which is in fact the truth?
Of course, there are principles of laws which guides a judge in getting to know whether party A is telling the truth or party B is the one telling the truth. We have all those principles, and they are a bit complex. Now, a judge, after taking the evidence, everything, will be looking at the character or the demeanor of the witnesses who appeared before him. Now, the court will also be looking at the veracity of your claim. The demeanor, the judge also can take judicial notice of certain matters. Judicial notice are matters which have gained so much notoriety within a particular set of system that the judge doesn't need to know that when you go behind in terms of football, when you go behind a certain line and score a goal, the judge, it is of judicial notice. Everybody knows it. And it is also of judicial notice that you have to place the ball in the center and pass it before you can move on. It is also judicial notice that you cannot carry the ball and run with your hands and go and score it into the net. It is of judicial notice. These are matters that a judge will consider in taking a decision. So matters of judicial notice is one. Discrepancies in your evidence, inconsistencies in your evidence between you and your witnesses. These are matters that goes to explain to the judge that party A is telling the truth and party B is lying to the court. And therefore comes to a decision.
Okay, thank you very much for that elaborate education. Hold on for us. Let's go to Daniel Krang now and see if we have a better connection to Daniel. So Daniel, law, fact, and truth. What exactly does the court determine, and how does the court come out with what it deems is the winning case to determine that one person must win or one person must lose? Okay, we understand we just lost Daniel once again. Unfortunate. I think what we'll do is that... Hello, Daniel. Hello, Daniel.
Hello, Samson.
Good. So, how do courts determine, that this person is right and that person is wrong? If I take my case to the court, how am I assured that what the outcome will be the truth?
Well, thank you very much. When you go to court with your case, there are three fundamental things that you need to concern yourself with. And these are, number one, the facts of the case. Facts of the case. Number two, your evidence. And number three, the law that is applicable to your case. Now, if I take them one after the other, let me talk about the facts. Every case that comes to the court is a history of a kind. Every case is a history. If it is a land matter, you are coming to recount or tell the court the historical background to your right to that land. How did you acquire it? When did you acquire it? What are the things that you did, the steps you took to acquire the land? These are the facts that you have to present before the court. Now, when you have narrated the facts, we move on to the evidence that you have. And just as Lawyer Ahmed said, when you say you have acquired the land, you have to produce evidence. And the evidence will be your documents or the presence of witnesses there. So everything you say in the fact, you must have evidence to support or to back it. Now, when you are presenting evidence, you must always make sure that the evidence you are presenting is credible, is something that the court can believe, is something that will support your case and will not defeat it. So when you have applied or when you have brought your evidence to support your facts, now we look at whether there are legal principles that support the conclusion that we can draw from applying your evidence to the facts. So a party doesn't just go to court to tell the court that this is the truth. We have to understand that there is nothing like truth before a case is gone into. When a judge sits to determine a case, the judge does not know the truth before the judge will go into the matter. And the truth that we concern ourselves with in court is a conclusion that we draw from your facts and your evidence. So when you have your facts and your evidence and we marry them together, we decide whether they are credible conclusions that we can draw. And so when we say truth in court, we mean the establishment of credible, believable facts. Establishment of credible, believable facts. Right. So you have your evidence, you have your facts. Is it true that you bought the land? Yes, because you have a document to support it, you have your lease to support it, so we draw a conclusion that what you have just said is true.
What if the evidence you are presenting to support that you actually bought the land is concocted?
Yes, that is where cross-examination will review. You see, the law has mechanisms to review deliberate concoctions and falsehoods. So when you say anything in court, you're not allowed to go with that. We will subject you to cross-examination to find out the veracity of what you're saying. The lawyers will, ask you questions to test whether what you're saying is true or not. And so I always say that when somebody goes to court with lies or a concocted story, and the person is able to get evidence to support that concocted story, and the person stands by that, the court is likely to believe that what the person is saying is true. Because the court does not concern itself with truth as we know in the Bible or in religion or even in morality. Before you go to court, there is no truth. The truth is established in the courtroom. Sometimes a party may have a very good case, but when you go to court and you're unable to present your case well, your case will be seen as false. And so evidence plays a very key role in determining the truthfulness or otherwise of parties' cases in court.
Right. Thank you, Daniel. Hold on for me. And now let me announce that our phone lines are all, as always, have been opened. We have about some 8 minutes that you can join us with your questions. So you can call now and ask the two lawyers whatever is bothering your mind about law, fact, and truth. Daniel had just finished doing a certain distinction of the truth that we get in a courtroom, the facts, the evidence, which is credible and as evaluated by the court. Lawyer Ahmed uses the term evaluating the evidence and the things that you bring in to be sure that they are credible. So there's a certain truth that the court may come to. So yes, to that extent, you can say that you can get the truth in the court, the evidence and the facts. If they are married and they are consistent and they trump what the other party is saying, then definitely you may get judgment, and that judgment will represent the truth. This is the law. It's your legal light. It's your help law. And my guest this afternoon that we have been speaking to, Musa Ahmed, is a senior lawyer. He is with Ahmed Law Consult, Ahmed Legal Consult, and Daniel Krang is lawyer. He is also an author of legal texts, several of them. He is with Adum Legal Consult. They are helping us to appreciate how the law works, particularly how what we present in court may result, the outcome that may come. Oliver, you are calling us from the Volta region. You are calling us from Denu specific, is it? Oh, you are Oliver Denu. Okay, you are calling us from the Volta region. Let's hear you, Oliver.
Yes, my name is Oliver Agboibo, calling from Denu, Volta region. Please, I want to ask if my grandfather owns a land and someone came for the land, or it has been disputed for some 70 years ago, and the case is still pending, then I come back as a big fan. That's the law court.
You said if what? State it again. State it again, please. I need to hear you a bit more loudly.
Yeah, my great grandfather owns a land from his father.
Okay.
And someone came, took over from the land from him. And the case has been pursued at the court. My great grandfather passed away. Then I, the great son, come and pursue that case at the law court.
Okay, thank you. Who is next? I can see the sort of the line appear to be jamming. Who else is on? Okay, so let's take an answer for you before we go. Oliver is called from Denu. Ahmed, you want to take his question?
Yes, if you can repeat his question, I barely could hear him.
Yes, Daniel, did you hear him? Did he seem to be talking about substitution? Because his great-grandfather...
The case is already in court, and is the grandfather dead? If the grandfather is dead, while the case was still pending,
yes,
then clearly he's talking about getting another person to be substituted or to get in
yes.
the
So,
action. So,
can he be made to assume and take over?
Yes, so can he be made to assume and take over?
So, can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over? Yes, so can he be made to assume and take over?
Definitely he can. But when you want somebody to be substituted, usually you look at the personal representative of the person. If it is a customary successor, the person will come in to continue the matter for the deceased or the dead person. So if that is the simple answer he requires, then I would say yes.
Okay.
Yes, he can come in to prosecute the matter.
All right. Thank you. I'll have Ahmed say something about that. But let's hear Samuel. Samuel, you are calling from Amasaman. What's your question?
I was incarcerated and I got an appeal. A study work a lawyer did for me, but the High Court granted me an appeal. But in the appeal to the High Court, it took time. It's about 3 years now, and financially I was handicapped, but I now raised some money to want to further the appeal. So I want to know if I can continue on with the appeal. That is what I want to know, because somebody I spoke with, a lot of people told me that the time for the appeal has elapsed, and I want to find out from a humble lawyer that what can I do in this case that the High Court has granted me the appeal. There's something I've not done, but I was wrongly accused, not getting a very lawyer to present.
Sorry, Samuel, I need clarity. You are saying you were convicted by which court?
Which court?
Which court?
A circuit court.
Okay, a circuit court.
Yes.
And then you filed an appeal.
Yeah, when I went to incarceration, I filed an appeal.
Mm-hmm.
And then the High Court granted me the appeal.
Okay.
But the lawyer was taking almost 500,000 Ghana cedis, and I was in incarceration, so I couldn't raise the money. So I came out, and everything has gone down. So in trying to raise money for the appeal, I couldn't.
Okay.
And it's 3 years now.
So you have already served the sentence.
Yes, but I still want to go for the appeal because I know I've not done what I was accused of.
Okay. Thank you. Please, the one on the line, hold on for me. Musa Ahmed, what would you say to his question if you appreciate where he's coming from? Generally, I must say.
To appeal against the conviction.
Hello.
Can you hear me?
Yes, I can hear you.
You mean the one that is seeking to appeal against the conviction out of time?
That is so.
Yes.
Yes, it depends on the time frame. Now, for final judgments, you have to appeal within 3 months. That's for final judgment. If it is an interlocutory judgment, you have to appeal within 21 days. Now, after the final appeal has even elapsed, you still have a period of about, for criminal trials, I think you have a period of about another 6 months or so. I'm not too sure about that. But in his case, he says he has already served a sentence of about 3 years. Now, to go back and file an appeal may be difficult, unless, from what he's saying, unless there is a fundamental breach of a certain law of substantive law. For instance, if, let's say, there was breach of rules of natural justice in relation to him, then there will be no time bar. It means that the resulting conviction was void from day one.
Okay.
So he can go to court at any time within his convenience. But he must act timeously.
Okay.
To set aside the judgment.
All right. Let me pick this very final call and then complete your responses. Joe, you are calling from Tema. I'm unable to pick any further calls. Hello, Joe. Let's hear you.
I want to find out whether head of families have any role to play in the preparation of letters of administration.
Head of family, what role does he have to play in what?
In the preparation of letters of administration.
In the preparation of letters of administration?
Yes.
Okay, thank you for that question. Yes, Musa Ahmed.
Yes. So, as I explained, you mean this particular one?
Yes.
What did he say, please?
Head of family, what role does he have to play in preparation of letters of getting letters for administration?
The rules of court has not made a provision for the head of family to be involved in preparation of letters of administration. But in the past, there was always the precedent that the head of family must confirm the applicants for the administration before a court takes up. And this, should I say, this precedent has permeated the system for quite a long time, to the extent that even to date, some of the courts continue to set that as a requirement. But I haven't seen that in the law. I haven't seen it in the law. It is a precedent. Since precedents become part of the law, maybe we will accept it. But if you look at the rules of court, the persons who are eligible to go for administration are listed there.
Yeah.
And there's no provision for a head of family.
Surviving spouse, surviving children, surviving parent, and surviving customary successor. Right. Daniel, having heard the questions that came up after the first one you answered, what contribution do you have to make to them? Hello, Daniel.
Yes, thank you very much. Concerning the... Yes, Samson?
Yes, go ahead.
Do you hear me, please?
Please go ahead.
Yes, concerning the gentleman who wants to appeal against his conviction, I'm a bit surprised that he's saying that the lawyer did a shoddy work. I don't know what he has seen or discovered from the judgment or the conviction that makes him think that the lawyer did a shoddy work. When you have been convicted, you have to look at what the judge in the court below said about your case, your facts and your evidence, as well as the law. If you have consulted a lawyer who says that your lawyer did a shoddy work, well, you can go to the appellate court and let the court know what went wrong and how that can be remedied, even after 3 years of, serving your whole sentence. Now, a bit about the customary, the head of family issue. Now, what is very fundamental about the head of family seeking to have something to do with letters of administration or probate is that when you look at sometimes the widow or the surviving spouse, the children, and the customary successor. The customary successor's presence in the case is for him to represent the family, of which the family head is the leader or the head.
All right.
And so the customary successor must always come together.
All right. I'm sorry, but we have run out of time. My guests have been Musa Ahmed, head Ahmed Legal Consult, and Daniel Koran, lawyer and author, Adum Legal Consult. This has been The Law. I'm Samson Lardy Anyenini. This is your health law. It is your legal light. See you next week.